Chapter 2, Law Merchant. Section 8. Meaning of term. The law merchant might be considered as a code of rules growing out of the needs of trade which the courts administering treated as distinct from the ordinary common law of England. The law merchant, in other words, is a system of law which does not rest exclusively on the positive institutions and local customs of any particular country, but consists of certain principles of equity and usages of trade which general convenience and a common sense of justice have established, to regulate the dealings of merchants and mariners in all the commercial countries of the civilized world. The law merchant is an example of how a custom or usage becomes gradually grafted into the law until it becomes as much a part of the system of law as any other principle in that system. It was first a mere particular usage which became general in its character and finally received the sanction of legal tribunals which recognized it as law. We must understand that the law merchant was no part of the law of England for generations after it had followed trade, in a private capacity, to the British Islands. Unlike admiralty and equity, it was for centuries a sort of tolerated outlaw, living only as the merchants could keep it alive. The law merchant is not a modification of the common law. It occupies a field over which the common law does not and never did extend. Section 9. Origin. The law merchant has gone through 3 stages in reaching the position it now holds in the legal tribunals. The first stage extended from the earliest times to the year 1606. Before this time the law merchant was considered as a special kind of law for a particular class of people. During this period the business of the commercial world was transacted or conducted in the great fairs held at certain places at fixed times each year, to which merchant and trader came. At each fair there sat a court to administer speedy justice, in accordance with the law merchant. To the merchants and traders there assembled. When any doubt or dispute arose it was settled according to the custom among merchants as declared by the merchants present. The second stage of the law merchant extends from the year 1606 when Lord Coke took office as Chief Justice of England until the year 1756 in which Lord Mansfield became Chief Justice. The most noticeable effect upon the law merchant during this period was the manner of its administration. The special court of the fairs died out and the law merchant was administered by the King's Court of Common Law. This court did not administer it as law but as a custom. As this court only administered it as a custom, the cases went to the jury without the facts and customs separated, in consequence of which very little was done in establishing any system of mercantile law in England. During the period, the third stage began with the year 1756 when Lord Mansfield became Chief Justice of the King's Bench and extends to the present time. The 30 years which Lord Mansfield sat as Chief Justice was the period in which a system of mercantile law was fully established in the common law courts. This system of law has been added to constantly by the addition of new usages of the mercantile world which have been proven to the courts. Bills of exchange at first extended only to merchant strangers trafficking with English merchants, and afterwards to inland bills between merchants trafficking the one with the other in England, and afterwards to all traders, and then to all persons whether traders or not, and there was then no need to allege any custom of merchants'. Thus in its origin the law merchant distinguished the contracts of foreign merchants from the contracts of ordinary individuals, construing them not according to the tenets of the common law, but according to the usages of trade. This custom of regulating dealings between native and foreign merchants was extended to dealings between native merchants, but was confined to the persons of merchants, as apart from those pursuing other vocations. And it was not until 1666 that courts declared that the law of merchants is the law of the land, and the custom is good enough generally for any man, without naming him merchant. Section 10. Origin of Bill of Exchange under Law Merchant. The Bill of Exchange is the earliest form of a negotiable instrument. Bills of exchange, which were first used by the bankers and merchants of Florence and Venice to facilitate the transfer of credits between distant points, came to England through France early in the 14th century, that is, came from the continent of Europe where they formed part of the modern Roman or civil law. The English merchant used it as an instrument whereby he avoided either sending money out of the country or bringing money into the country. to pay a third party, he would give an order on one of his foreign debtors. Originally, a bill of exchange was purely a trade transaction, which was a means whereby one country avoided sending money to another. Section 11. Origin of promissory note under law merchant. Promissory notes are said to be of great antiquity and to have been in use among the Romans, but the negotiability of these instruments was unknown among the Romans and is a development of modern times. The time of the introduction of promissory notes into England is not absolutely known, but it appears to have been about 30 years before the reign of Queen Anne. They were in use a considerable time before they became the subject of litigation and legislation. The common law judges were opposed to the negotiability of promissory notes payable to order or bearers, and it became necessary for Parliament to legislate upon the matter, the result of which was the enactment of a statute conferring upon promissory notes the same qualities of assignability and negotiability as were possessed by the Inland Bill of Exchange. Section 12. Law merchant codified. In the 17th century, the law of bills of exchange was codified in France, but in England no general codification took place until 1882, when the English Bills of Exchange Act was enacted. In the United States, the earliest general codification is found in the California Civil Code in 1872, but this has been followed within the last decade by a more widespread adoption of the Negotiable Instruments Law on the general lines of the English Bills of Exchange Act in most of the states of the Union. In some of the states, however, the unwritten law merchant, as incorporated into the English common law, still governs, although it has been modified in various ways by judicial construction and statute in the several states.